Well, I just want to make sure everybody looks like they're ready. Are you ready, ma'am? Okay. State versus Torres, and Mr. Bergmann, you may begin.
Thank you, Your Honor. May it please the court, counsel. Your Honors, I want to thank you on behalf of myself as an Iowan and my client on taking this case for further review. If the decision of the Iowa Court of Appeals is allowed to stand in this case, it will significantly change Iowans' protections under the Fourth Amendment, how police can avoid Iowans' constitutional rights, and how police can engage in increasingly intrusive investigations, including into our own homes. In the case below, the district court should have found that Mr. Torres was seized, as we call a seizure under the Fourth Amendment, that there was no probable cause to seize him or to enter his home, that there was no reasonably articulable suspicion to engage in a warrantless search. The fact of the matter is that Santos Torres was seized as soon as he arrived at the scene.
When they told him where to park, how is that a seizure? It's a narrow street. They want to allow room for other vehicles to get through.
Your Honor, however, the unambiguous language on the Fourth Amendment says that directing someone where they can and cannot go is a hallmark of a seizure.
To just set the stage a little bit, in my opinion, more accurately, he came upon what could possibly be considered a crime scene. There's an active investigation going on by the Department of Human Services on an allegation of child abuse. So it's not like he just plain was going home to have some SpaghettiOs with the family. He's there, and there's something big going on.
I actually disagree with that significantly. First of all, there is a DHS investigation, which of course is not subject to judicial oversight, and then there is a criminal investigation. Now, in the criminal investigation, the mother, my client's wife, has already been arrested, cuffed, and put in the squad car. The evidence has zero, there is zero in the record that there was a taped outline of a body that they had to take a photo, or that there were placards to put up on the shelves, or that there was...
I have a question about the record, and maybe you talked about this with the Court of Appeals. It does seem like there was a video that begins, because the one we have begins after he's been arrested. So we don't have any video of the entry into the house or anything, and that would perhaps have been helpful to us in our review. Was it part of the record and we just don't have it, or was it not made part of the record?
To be honest, I tried to figure that out, and I couldn't figure it out either, and I didn't recall it clearly enough. But luckily enough, the officers gave up the goods in the hearing. And basically everything in the hearing was undisputed regarding whether they were invited into the home, what happened, what they told him to do, where he could go, whether he could use the bathroom in his own home, whether...
Here's the way I view it. I mean, and maybe that's why I was interested in the video. If we conclude that the officers were not really impeding him from going into the house and moving around the house, at that point he's not seized, and pretty soon after he gets into the house, it seems that people start to notice he's showing signs of intoxication. The issue for me is the Caniglia one. Can they go into the house? And that's where I have my concerns about that. But I wonder, there's a logical. It might be logical to say they can go into the house if, I think as the chief was suggesting, if they're trying to protect this DHS worker that is alone inside, and you have an agitated individual in Mr. Torres who's also going inside.
Be prepared for a long response. So just last year, the U.S. Supreme Court said, as you noted, I'm quoting here, the community caretaking doctrine does not apply to warrantless entries into the home. That's about as clear as it gets. Now I want to pose a different idea.
So as I understand it, he's in the home with Officer Conrad, and then a child is coming in and out of the house, and it's Officer Buehrer that's outside that then comes in, I think, to sort of make sure that the kids are being looked at or watched, because the police just put their mom in the police car. And it's Buehrer that then goes inside, and he's the one that starts talking to your client, and he's the one that then brings your client outside to run the sobriety tests.
I mean, that skips a bunch, but for instance, the grandmother's already there. The grandmother's already been called, and the grandmother is taking care of the kids.
I could differ with you on that one. That cannot be an assumption. Oftentimes, grandparents, uncles, aunts, there's might be a multitude of people involved in that child abuse assessment.
So I don't recall exactly how much of the underlying case made it into the record, and I don't really want to introduce other things. But I think the record here does reflect that the grandmother was called there because the mother was getting arrested.
Agree with that, but doesn't it also show that the DHS worker was in the process of interviewing the three children and also wanted to interview your client?
Well, that would be lovely that she wanted to interview my client, but the fact of the matter is, had he called me, I would have told him not to respond, as I do to most of my clients. He's under no obligation to speak to a DHS officer, and they're not a cop, they're not a police officer. And even if they were, he wouldn't have any obligation to talk to a police officer.
I mean, I understand Caniglia has some broad language, but, respectfully, the United States Supreme Court justices don't deal with these kinds of cases usually. They all come from, or many of them come from the DC Circuit in administrative law. And here we're doing with nuts and bolts of people's lives in everyday life. And we just heard a case about domestic violence, and now we have a case about a kid that, things that are that sort of thing. And so isn't it legitimate if I was a cop and I saw your client walking, kind of upset and angry, storming into the house, and I know that a DHS worker all alone in there, that I might want to follow your client into the house and make sure that the DHS worker is going to be all right? And a child, and the children?
Bergmann walking into his home that knows all of his rights and wants the cops out of his home and says, "Get out of my house."
His wife arrested and sitting in a cop car while I'm not convinced that the child endangerment criminal charges were complete. Yeah, they had the wife in the cop car, but are you saying that taking care of the children that are the subject of the child endangerment charges is not part of the police's job? What if the DHS person wasn't there? Oh, we've got the mom in the car, we're just going to leave and leave the kids? I'm not sure how do you draw that line, and why are you so convinced that the criminal investigation was over?
Because no one from the Court of Appeals or the state has proffered exactly what was supposed to go on in the criminal case.
I want to draw your attention to the statutes. 232.71B is duties of the department upon receipt of report, and it talks about 24 hours they need to get on it and go to the place. There's a subsection 3, involvement of law enforcement. Subsection A, blah, blah, blah. The county attorney and appropriate law enforcement agencies shall also take any other lawful action which may be necessary or advisable for the protection of the child. Why doesn't this fit there?
This isn't lawful, it's in violation of my client's constitutional rights.
And you're saying that the child's rights are being protected? I mean, I don't know what the allegations are, and I don't want anyone to think that I know that I'm saying that is your case. But I can envision a situation. Let's say parents are strung out on drugs. They're doing it together. They have all kinds of druggy people come into their house. Let's say they both. So they get this report. They go there. They snag mom. They put her in the car. They got one, and they find all kinds of other drugs in the house. And then dad comes home. You don't want him flushing stuff. You don't want him hiding stuff. Why is that not? Yeah, normally you do, but there are times when a warrantless search is appropriate, or not a search, but a warrantless entry, as you're calling it, is also covered in a statute.
Because in order to meet muster under the Fourth Amendment, the officers would have to have a reasonable articulable suspicion of what was going on. And they don't just get to come into Santos's house and start snooping around and stand outside the bathroom, both of them, like he's a prisoner of war.
Wasn't a DHS worker in the house.
So, Your Honor, I would like to push back on you then. So what happens after this case? So guess who's coming along to every ride with the cops is a DHS worker. And if the bachelor uncle who has the nephew come over twice a year to watch the football game, then a DHS worker comes over and we can say, well, there was a concern about the nephew because of a report, well, the uncle likes to drink a bit too much when he's watching football. And then now we've expanded the Fourth Amendment to meaninglessness.
Caniglia, if I recall, and it's been a while since I looked at it, wasn't that a suicide or a potential suicide case? I thought that they were entering in response maybe to a potential suicide. But setting that aside, I just want to clarify exactly what you're arguing. As I read your brief, you were not arguing about the legality of the entry into the home. You were arguing that he was seized at all points from exiting the car. Is that, just to make clear, we've talked about the home, but that's not what you argued in the brief.
A little further in time when he's told where to go take the car or take his vehicle. I think that would be the beginning.
Is really not the legality of the entry in the home. It's the seizure of your client at some point in time before he entered the home. And it's your contention that he was seized all throughout that process. Correct. Okay.
Also including the idea that the place in which we are most secure in our persons and things is our home.
Before you, I mean, the fact that he's allowed to enter the home isn't that inconsistent with a seizure, which is a reasonable person would conclude they're not free to leave?
I would think that that was him making his effort to go somewhere where he's supposed to be safe from these intrusions.
What exactly do you want suppressed? Or what specific pieces of evidence should have been suppressed?
Of the officers from the moment that they take him, they direct him from the vehicle until the end of their interaction.
What about the DHS worker's observation? I think she's the one who first observes maybe he might have been drinking. She could smell an alcoholic beverage, I think, on his breath. What about that?
She is not a peace officer, and so I've only thought about that this way. Her observations that she's not a peace officer are not imputed to the other peace officers. But I would still seek to have that suppressed.
The argument that the state makes that Buehrer was properly in that house to protect the children and then noticed that your client was intoxicated.
It's the Fourth Amendment. I mean, it says in Caniglia, the community caretaking doctrine doesn't apply to a warrantless entry. And there has to be something more than what this record reflects.
Your argument that Buehrer should not have been in that home even to make sure that the children were okay. In other words, when he apparently brought one of the children from outside to inside to make sure that they were sort of corralled in one place, that wasn't proper?
That's not proper, because I consider the times when I go on a trip with my wife and my mother watches my kids. That doesn't, and while I understand that there's more going on, it doesn't.
Forget about the DHS being in the house investigating a complaint of child abuse. Don't make it sound like it's just visiting mom.
True, but on the other hand, that has happened before my client even comes upon the scene. So their involvement has already begun before he has decided that he wants to be involved in it.
About the DHS worker's information to the police. So let's assume he was seized at the time you said, but then the officers learn or gain information from an independent source, here the DHS worker, who you say is not a peace officer. Can that after the fact information justify or provide independent justification for continued seizure? So think of the fact pattern here. Let's say they had seized him.
Right.
And somebody comes up independently and says, by the way, officers, I saw that man put drugs in his pocket. Can they now seize him for that independent reason that's unrelated to the initial seizure?
Trying to keep all the facts straight. But if he's in the cop car and he's got the drugs on him, no, because they're going to find him when he gets to the jail, right? Like he's going to be put in jail clothes and they're going to find him. And maybe, let me try and answer your question this way. If the idea is his intoxication, is there a level of intoxication in which a parent can still parent their child? Okay,
My concern is, let's say it is intoxication. He knows that house better than anybody. He knows where there's a gun. Maybe he's upset. I have no idea what the allegations are by the children. Let's assume that it's something particularly heinous. Yeah, him going into the house is a very legitimate concern.
it's counting up on me. I think that means I'm out of time.
But you'll get another chance. You get another crack at it. So why don't we?
You when I have my next 5 minutes. Thank you, Your Honors.
May it please the court, Mr. Bergmann. In the words of Chief Justice John Roberts, the role of a peace officer isn't simply to prevent violence, or, I'm sorry, I just messed up our poor chief's words. His words are, the role of a peace officer includes preventing violence and rendering aid, not just, addressing casualties after the fact. And part of that includes restoring order. And in this case, I think we sort of have the almost a quintessential example of police officers not executing their not executing their criminal investigatory roles, but instead are there to ensure the health and welfare of.
Now we run into Caniglia, which was sort of decided after the district court proceeding and while this case was being briefed. And as I understand it, it's a 42 U.S.C. 1983 case. So the U.S. Supreme Court must have thought it was obvious all along that qualified immunity doesn't allow warrantless entries into a house for community caretaking. Is the entry into the house, is it preserved or not? Because I see it being argued on the application for further review. I see it being discussed. I see the Court of Appeals saying it's not before us. I see the dissent in the Court of Appeals saying it is before us. Is it part of the case?
And you can find that in the defendant's reply brief, in which he expressly states, Caniglia is not applicable to this case. Those words are in the reply brief. And in his initial brief, and in his argument below to the district court, it always was the seizure by Officer Buer. He's the one, not you. I think you have your officer and your deputy confused. It was the exact opposite of what you were saying, but you generally had the facts correct, Justice McDermott. But here, it was only ever, did Officer Buer illegally seize the defendant? There was never an allegation that the DHS worker was in the house illegally or was doing anything other than a proper investigation. And there has never been an allegation that Deputy Conrad entered the home illegally or seized the defendant. So we're really only talking about whether or not the actions of Officer Buer when he encountered defendant outside of the home when he arrived amounted to a seizure that was illegal under these circumstances. And the state, of course, believes no. And the defendant wants you to believe that the seizure began when he was directed where to park. I say no to that for two reasons. One, the street was partially blocked off, and the officer was simply directing him, as all officers would, where a person could park so not to continue to obstruct traffic. Two, the idea that you would allow someone to get in their car and drive away if they so choose can't amount to a seizure. He, at that point, could have gotten in his car and left. So that part is not, a seizure. And then we have him arriving at the house and starting to speak with Officer Buer, who says, I had some suspicion that he had been drinking. And he was agitated and uncooperative and upset. And then he went into the home. And so Officer Buer followed him because at that time, the DHS worker, Ms. Roy, was inside the home interviewing the children. And so Officer Buer said, I followed him into the home for safety reasons. That's in the transcript.
Would Mr. Torres have been able to say, I don't want you to enter. I'm going into my house. You wait outside. DHS workers allowed to be here pursuant to this statute, but you don't need to be here.
Probably no. Under the circumstances of this case, he wouldn't have. But that one didn't happen.
Effectively seized if he had no right to disengage himself from the observation and supervision of the police officer, isn't that effectively a seizure?
And I rely on the line of cases where sort of it's a little bit, maybe a little bit different situation, but where officers execute search warrants, they can, sort of stand in, or before they execute a search warrant, they can stand inside a home and observe, what's going on, and that doesn't amount to, searches or seizures. And I think this would be sort of similar. The officer would still have been permitted to go inside the home and observe inside the house what was happening without that amounting to a seizure. But even if it did amount to a seizure, it certainly wouldn't be an illegal one under the circumstances of this case when we have both an ongoing DHS investigation and perhaps an ongoing criminal investigation in terms of what the mother, had been doing prior to the arrival of officers that was reported to the police.
Pat him down inside the house.
Restroom is my understanding.
Sure.
Oh, and I think under the circumstances of this case where I think the record shows that while the Officer Bureau did follow him around the house, he did not restrict his movements. He went upstairs, downstairs, upstairs, bathroom.
Be a seizure, a pat down.
Under the circumstances of this case, what I'm saying is that he went into a bathroom and he was in there for a long time. He knows this house. He could have something like a weapon in the bathroom. And so what the officer is doing is trying to maintain control of the scene and maintain control of the safety of the people in the house. And so by performing
For the seizure, it doesn't deny the fact that the seizure occurred under Terry. I mean, if the officer lays hands under Terry or Hodari D, that's a seizure. And then we can argue about the legality of it and whether it was justified. But he was clearly seized at that point, right?
I think that there is ambiguity on how, in terms of what the
Seizure. I mean, there's a Terry pat-down is a level of seizure, and it could be based on some reasonable suspicion that he might pose a danger to the officers. If he's angry and he's going into the restroom for a period of time, they're not able to observe him, and they're concerned about safety. That might be independently justified. There's also a custodial seizure. That didn't happen until much later, right?
To be fair, part of the ruling of the district court is that the officers were engaged in a community caretaking function, because this was pre-Coniglia, and that under that idea, of course, then, that assumes that there was a seizure.
Can't have changed the law because it's a damages case. It's a case under 42 U.S.C. 1983.
Coniglia did was clarify that Katie does not apply to the home. And as we can see from the other, the dicta in the case and the concurrences, all of the justices clearly believe that these actions are still acceptable under different exigency or other, warrantless entries into the home exceptions that have been established for a long period of time. It's simply that Katie itself never meant to be so broad.
The exception here, if not community caretaking.
I think it's somewhat ambiguous after Coniglia because, and I think the concurrences, recognize that there's going to be litigation in this area trying to make that determination. For me, I think it would be somewhere around the emergency aid doctrine where the police are there to facilitate, an ongoing situation with DHS, with the health and safety of the children, and therefore, you are correct that it was a suicide case. It was a wife called, police concerned that her husband was going to commit suicide and had firearms in the house.
Said those facts clearly established did not allow the officers to enter the home.
Your Honor, they said that they didn't allow them to enter the home under the community caretaking exception, and that the parties below did not argue for any other independent exception to the warrant.
On the scene, the guy, that's what I remember the facts. He wasn't on the scene. They were worried about the firearms, and they said, yeah, so that's different on the facts, but nonetheless, it has broad language. And if it's a case under the Civil Rights Act rejecting qualified immunity, that has to mean the law was clearly established in the U.S. Supreme Court's view beforehand.
There was a case from the Eighth Circuit, U.S. v. Sanders, that had gone up where they had used the community caretaking exception to justify the entry into the home. It was
In a footnote, and I thought overturned it. I thought that was footnoted in Caniglia, the Eighth Circuit case.
Where I'm getting to, Your Honor, which is that it was overturned and sent back down after Caniglia because they could no longer use the community caretaking exception. But on remand, the Eighth Circuit found that the emergency aid doctrine applied instead and still upheld the search or entry into the home in that particular case. And so I think that is an example of a situation similar to this, where in the meantime, a court has had been relying on the community caretaking exception. Caniglia has ruled, it gets remanded, and the decision can be made that that the courts anticipate that there are freestanding exceptions to the warrant requirement that exist in the law already.
District court didn't rely on emergency aid in this case. What are we supposed to do with this case? Should we remand it?
Question. I think under the facts of this case, it's possible to reach the result under the emergency aid doctrine. If not, I think a remand would be necessary to make that determination because the parties were operating under the assumption that this exception existed. And so, of course, maybe the facts are a little bit different. And it would give the parties a chance to litigate that for the first time in the district court to decide it.
Find that the officers were justified in going into the house to protect the social worker.
Or did two.
Those facts enough to support emergency aid? So if we agree those facts are enough, we can affirm.
I think.
Counsel, I thought, and I got the names wrong, I thought that Conrad went in not to protect anybody, but to make sure that the children were sort of corralled. So it was a different basis.
That is correct, but I think what the district court said is they had two findings for their ruling. One was community caretaking and one was exigency. And I think part of the exigency can be Deputy Conrad's because the children who are 9, 6 and 4, who are very young, were wandering in and out of the house and were not being taken care of. So Deputy Conrad went inside to corral the children because Ms. Roy was getting prepared to speak to their father and they wanted them away from him while she was speaking to them. And while he's in there, he overhears, the conversation with Roy about his impairment and then he waits until their discussion is finished before he takes him aside. And so I think that the exigency of the entire situation allows him to be there. And of course, the defendant never challenges those entries. And so I think even if...
Point. So Caniglia, emergency aid doctrine, exigent circumstances, all the things we've been talking about all relate to warrantless entry into the home. And as I understand it, what you're saying, and I think what Mr. Bergmann said to me, is he's not challenging that. We're only looking at the seizure. So these cases really are inapplicable as stated in the defendant's reply. It's, was the defendant seized and was it justified? In the home, while it may be a relevant fact on whether he felt free to leave, et cetera, that's not the doctrine that's at issue in this case. Caniglia, exigency, et cetera, right?
The holdings and the reasons behind those cases are applicable to deciding, if you do decide there was a seizure, whether or not it was reasonable or not under the circumstances of this case based on, the surrounding circumstances. And in my original brief, I really just focused on the suppression issues here because I think even if you assumed that Officer Buer had him illegally seized, which I don't believe is the case, I believe this was a legal seizure if there was one, that any of the evidence collected by Roy and Conrad is not suppressible because that evidence was not gathered because of the illegal seizure. There's no indication in this record that the police, prevented him from entering. There's no indication in this record that the police, forced him to speak to Roy, kept him in the home against his will, and then therefore he, made these statements to her in which he determined that he was impaired. So even if there is some sort of illegal seizure, these are attenuated. The collection of the evidence is attenuated from those actions. So I think regardless of where you come out on the seizure issue, none of the evidence gets suppressed because Officer Buer, the one who is, the allegation that he is the one who's doing the illegal seizing, never testifies to any observations of intoxication. The only thing he ever said at the suppression hearing was, I had an initial thought that he may have been drinking, but that was to inform his choice in following him into the home to provide safety to the ongoing investigation. So there is nothing that Officer Buer saw or stated that could be suppressed. Yes, sorry.
Mr. Torres argues that the police officers work in tandem, and that you can't sort of say, well, yes, one may have seized him improperly, but then the other one comes in and has some separate basis, and then it's okay. What's your response to that argument?
To that general principle. But that's not what happened here. And that's why I'm saying, even if he was illegally seized, the evidence collection wasn't a result of that illegal seizure. It wasn't that you have one officer with unclean hands and one officer with clean hands, and then you can just claim, I swooped it. Like, if someone invoked a Miranda and then a different officer came in and started talking to them, we wouldn't say, you get to get that second information in because clearly they're connected, clearly he has invoked a right. But in this case, the causal connection between the collection of the evidence and any alleged illegal seizure doesn't exist. And for that reason, that's why it wouldn't be suppressed. And for all those reasons, we ask you to affirm the district court. Thank you.
Honor, I honestly don't have much to say.
Issue?
I don't agree with that at all. As Justice McDermott's question led, this is a tandem effort by the officers. And what's attributable to one is attributable to both. There's lots of danger in this case, Your Honors. If Your Honors split this case in that Buer did one thing and Roy did something else, then all that's going to lead to is police actions always done by two individuals. And then one may engage in unconstitutional activity, but the other one can save the day by not engaging in that activity, and then the evidence gets to come in anyway. So no, I don't agree with that argument at all. And sorry to talk over you there. I was going to say that famously I once told Judge Colleton in the Eighth Circuit I don't have much to say, and he had a smart comment, but then he used up all my rebuttal. I did not engage in a smart comment at the end. But what I want to say is this. The word agitation has come up here, and the reason agitation comes up is because we did a trial in the minutes, and one of the ways that the state tried to prove up the case is by agitation. Was Mr. Torres reasonably expected to have any other sort of reaction, any other sort of emotional reaction than to get a call that you got to get home because DHS is here and your wife's in the back of a cop car? In fact, I've been listening to Charlie Munger and engaging in the inverse thinking. Like, how do you prove how to do something good? Think about how to do it bad. What if Mr. Torres was very stoic and had no reaction whatsoever and was dead-eyed, had no comments whatsoever, simply arrived and stood there?
On him?
Would that have given the same justification to everything else that happened? Probably.
Agree with you. I don't think it rises or falls on his reaction. I think that's part of the mix. I'm interested. I mean, have you waived the argument that the entry into the house was improper? Are we just dealing with the seizure argument? I just want your position. I understand the state's view. It's been waived.
I see that it has been waived, though I would argue that my focus in my argument has definitely been the seizure. That's how I would leave it.
That earlier, you said yes. The only thing at issue in this case is the seizure, not the entry into the home. That was what you said in your first 10 minutes.
I agree with you. I think your question was the timeline, right? And is that the focus? I mean, the focus is the seizure, right? And then, as I think we've come to understand, the fact that he's retreating to his home does also apply here.
The district court wrote in denying the suppression motion, under these circumstances, that's where he comes and he's upset. His wife's under arrest and they may take his kids away and he's maybe intoxicated. The court concludes that the officers would have been derelict in their duty to leave the defendant unattended in this situation, that they were, in other words, justified in following him around the house.
I don't think you could be more wrong. The one other thing I want to talk about is the idea of, and DHS agents do a really tough job. They do a really tough job, but I think that, as Your Honor talked about, that we're down here in the real world, to think that DHS agents have anybody that works for the whole state of Iowa doesn't know how to handle someone that is upset is really a farce. I mean, if anybody on the payroll of the state of Iowa can handle someone that's upset, it's a DHS worker that probably deals with it every day.
Scary situations that they're put into. We've had social workers murdered at the scene. So I beg to differ with you, and I think they are very good at what they do. But I think there's a statute here that has an involvement of law enforcement for a reason. I'm trying to figure out how it doesn't fit into that.
Then, Your Honor.
Right, the investigation had just started. Just started. There's still, the traffic is still crazy outside. He was at a bar or wherever it was, just got there. This is the beginning of an investigation. Trust me, I've read lots of assessments. It's going to be 30 pages long, single-spaced. It's going to take, they're going to be there a while.
Therefore, because we have a DHS officer there, we're going to have to continue this criminal investigation and waive my client's Fourth Amendment rights because there's a DHS investigation. That's where we're at, is there's no end to it.
Been drinking, and that raises a red flag, doesn't have anything to do with child welfare.
Your Honor, it goes to the issue of, first of all, the danger here. And the danger here is that when does it end? Is there going to be a time when we can ever say that it's over? We know when the ticket's given to a motorist, it's over. When they've got the alleged individual of the child endangerment case that does not involve Santos Torres, there's no argument that it involves him, in the back of the squad car, and the only argument the state can come up with is that there's a DHS agent inside, that implies the criminal investigation is over. And so now an incorrect ruling from this court will simply have DHS officers in the squad car with the officers to continue investigations ad infinitum. So, Your Honors, I ask you, not so much for Santos in this case, but as an Iowan, overrule the Court of Appeals. I would agree to a remand and clean this up. Thank you, Your Honor. Your Honors.
State versus Torres is hereby submitted, and we are adjourned for the afternoon.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.